Yes, Mr. Deepang is out of station. Okay.
What's the I think I have been instructed for intelligence. Primary, okay. Yes, CRT along with the I.
Item number 1.
My please, Lordship. My lord, last time we were on the my lord, issues on the my lord, Order 41, Rule 27. My lord, my lord, Lordship, DC. Even your Lordship was supposed to was about to issue notice, my lord. Well, I prayed, well, no, my lord. My lord, here, my lord, the only Lordship has to see is whether Order 41, Rule 27 was complied or not, my lord. That was the I wanted to convey that has not been there in this matter, madam. Yes, yes. Let's yes, madam. Now, no. That's why, I wanted to convey the provisions of Order 41 rule. Yes. No, madam. That's what. Yes, madam. Yes. Madam, why the lacuna, Lordship, I wanted to show, madam. The Order 41 Rule 27, madam. There are 3 clauses, madam. First two, madam, CPC, madam. Yes. Madam, Order 41, Rule 27, madam. Yes, yes. Yes, yes, ma'am. Yes, ma'am. Lordship got it married. The High Court, in case arising out of original suits or other proceedings of the value exceeding 1 lakh rupees, and the District Court in any other cases, include cases arising out of original suit or other proceeding instituted before the commencement of court, civil procedure court. I'm sorry, my lord, reading. The High Court may call for the records of any case which has been decided by any court subordinate to the such High Court and in which no appeal lies hereto. And if such subordinate court appears to have exercised jurisdiction not vested in by law, yes, to have failed exercise jurisdiction so vested or to have acted in the exercise of jurisdiction illegal or with material irregularity. I'm on the third ground, madam. See, material illegally or with material illegally. Yes, irregularity. My lordship, that's why I'm. No, material irregularity exercise, madam. Now, that's why order 41 rule 27 has not been followed, madam. Order 41 rule 27 has not been followed. That's the madam, substantial question of law which we are raising in this present revision petition. May I read order 41 rule 27 again, madam? Rule 27. There are 3 clauses, madam. Rule 27. Order 41, rule 27. May I read, madam? Production of additional evidence in appellate court. The parties to an appeal shall not be entitled to produce additional affidavit, whether oral or documented in the appellate court, but if this is the court from whose decree the appeal is preferred has refused to admit evidence which ought to have been admitted, madam. This is not our case. It is not a case that the trial court has refused. This wouldn't be in our case, ma'am. Yes. Well, the respondent prayed for. No, in appeal memo it's not mentioned. That's why we have annexed the appeal memos. We have annexed the appeal memos. This is not the case that, first, second, AA, madam. The parties seeking to produce additional evidence establishes that notwithstanding the exercise of due diligence, such evidence was not within his knowledge or could not, after the exercise of due diligence, be produced by him at the time when the decree appeal against was passed. When the decree was passed, madam, it was even after due diligence, he could not produce it. That should be the ground, madam. That is not the ground taken by the respondent in the petition. Now, third part, madam. Third part is, madam, is totally different matter, madam. This is the discretion of the appellate court, madam. Third portion. The appellate court requires any documents to be produced or any witnesses to be examined to enable it to pronounce judgment, madam. This at the time of judgment, if the appellate court feels that the evidence that has been laid is not sufficient, the appellate court has the discretion to call for the new evidence from the records. If it says this witness is required, these documents are required to pronounce the judgment, madam, or for any other substantial cause. Or substantial cause has been, so Honorable Supreme Court has already decided, madam, what is the substantial cause? Substantial cause means the court requires it to pronounce the judgment. At the time of pronouncing, madam, I'm not saying the court doesn't have the power, madam. Court has the power to call for the records, for the witnesses, everything. But its discretion applies only when the court is unable to pronounce the judgment because lack of the material before it, madam. Then only court has the discretion to call for the records by its own discretion, madam. On the other two parts is, madam, when there's an interlocutory application filed by an appellant before the court, madam, these two part has to be seen. The last part is, of course, the discussion of court, madam, while pronouncing judgment, madam. Here is a case, madam, where the application has been filed. There is no ground that due diligence. Yes, madam. Therefore, madam, the appellate court may allow such evidence or documents to be produced or a witness to be examined. This is a discussion when the, yes, madam. Now, wherever additional evidence is allowed to be produced by an appellate court, the court shall record the reasons for its. Yes. Yes. No, madam, first of all, the discussion is when the appeal was not heard by the court, madam, because only the interlocutory application was heard by the court. When the appeal is heard, the court feels that, yes, this document is needed, madam. Court has the power to call for those records. I'm not saying that, but the court doesn't have the power and discretion to call for that. Yes, discretion is there, madam. I'm not saying it's not there. Yes, madam. Yes, erroneous exercise of power, madam. Because this order has been passed based on the application, madam. Yes, appellate court. Yes. Yes. No. Malot? No, I'm not, yes. I'm not disputing that, man. No, I'm against the irregular exercise of power, malot. That's why I'm submitting. No, what I'm submitting is, malot, this ought to have been, malot, if the discussion is applied by the learned appellate court, malot, it ought to have been in the third ground, malot, not on the basis of first two grounds. Yes. 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 No. Yes. No. No. Yes. But, but that will be an appellate stage if it goes against us, malot, in the field. It was not, that's why I'm saying it was not mentioned. That's why I'm saying it's illegal. But Order 41, Rule 27 has to be followed, man. That's why I'm submitting. Man. A court has the power to allow, madam. Lordship will see impugn order, madam. Madam, that has to be, yes, yes. That's not applicable. That's not applicable. That's for suit, madam. Before the madam, filing of suit, the requirement. Yes. Yes. Not, no, madam, the orders, 41 rule 27 lordship has already seen. When it requires for pronounces judgment, madam, that's what I'm submitting, madam. Now, yes, order for lordship will see order to learned appellate court has said order 41 rule 27B, madam. That is for enabling the court to pronounce judgment, madam. At the time of judgment, if the court feels there's a difficulty in pronouncing judgment, then only these provisions can be invoked. Madam, may I just refer, madam, I have yesterday submitted some judgments, madam. Madam, 27B is to enable the court to pronounce judgment, madam. Madam, yes, I admit to that, madam. No, madam, your lordship has already seen the order 7, which the learned appellate court has said, madam. Order 7 rule 14 doesn't apply, madam. It's for new suit only, madam. Now, the learned appellate court has said order 41 rule 27 under this provision, it has allowed the madam, application, madam. That is perverse, madam, in my humble opinion. 107, madam, is it empowers the appellate court, madam. Madam, that is enabling provision, madam. That has to be guided by orders and rules. We are not denying, madam, appellate court has the power. Madam, this is enabling provision, but that has to be guided by orders and rules. Yes, sir. Powers of appellate court, madam. Subject to such conditions and limitations as may be prescribed in appellate court, madam. This is subject to conditions and limitations. As may be prescribed, an appellate court shall have power to determine a case finally, to remand a case, to frame issues and refer them for trial, to take additional affidavits or required to such evidence to be taken. Yes, yes, yes. Yes, a subject as aforesaid appellate court shall have the same powers and shall perform as nearly as may be same duties as are conferred and imposed by the court on courts of original jurisdiction in respect of suits instituted therein. That's why, madam, the sections and orders cannot be separated, segregated. The sections has to be guided by the orders. Yes. Yes. I'm not denying. I'm not denying. I'm not denying that, Malad. Malad, I'm denying the lordship. The order 41 rule 27 would not have applied in this case, man. That's why I'm submitting. Yes. Matlab, it has to be with reason saying that it is for enable the court to pronounce judgment. Matlab. Then that's for pronouncing judgment. 27B. Yes, we are not denying. Supreme Court has time again said, this order 107 has to be read with order 41, rule 27, while allowing additional new evidence before the appellate court. I'll just read only one judgment, I submitted 3 judgments yesterday, but that's what I'm submitting. That has to be guided by this clause AA. Nothing's there in their application, that due diligence was made but couldn't find the documents. That's not a single whisper in their application. He has not even annexed the document in the appeal. No. He said he has purchased the land. That's all. But no, wife. Yes, ma'am. But he has not. He has not in application. He has not said. He has. Even after due diligence, that's the mandatory thing that he could not trace up. No, nothing, no whisper regarding that one. Approximately 3 paragraphs on the application. But due it's not said that due diligence, even after due diligence, and he could not. It's drafted by an advocate, not by him. Even after due diligence, it was in his not in his knowledge. That is the mandatory ground that has to be taken. No ground has been taken in that 3 paragraphs. Only sentences that not traceable in the application. 3 paragraphs application. And that application was not even page 58. Kindly see once their application. Yes, but it's yes, the sentence is to be while passing of the decree, even after due diligence, he could not produce before the court which passed the decree. That is the AA. That is not there. Not a whisper. Yes, Malad. Yes. Malad, just Malad, 2000 Supreme SC, this is in case of Malad, Mahavir Singh and others, Malad, and Naresh Chandra and others respond. The lordship got up submitted. Yes. Here, para 5, Malad, from 5 onwards. Here, Malad, those are given. Before we proceed further, we would like to refer to scope of an application under Order 41 Rule 26 CPC, Section 107 CPC enables an appellate court to take additional evidence or to require to such other evidence to be taken subject to such condition and limitation as are prescribed under Order 41 Rule 27 CRPC. Principle to be observed ordinarily is that the appellate court should not travel outside the record of the lower court and cannot take evidence on appeal. However, Section 107D CPC is an exception to general rule, and additional affidavits can be taken only when the condition and limitation laid down as rules are found to exist. Yes, Madam. That has been explained further, Madam. The court is not bound under circumstances mentioned under the rule to permit additional affidavits, and the parties are not entitled as of right to the admission of such evidence. And no, that is given how the discussion should be there. That I'll just let me just 2 minutes only. Additional evidence parties not entitled to as of right to the admission of such evidence, and the matter is entirely in the discretionary court, which is of course to be exercised judicially and sparingly, madam. The scope of Order 41 Rule 27 CPC was examined by Privy Council in such and such, in which it was laid down clearly that this rule alone can be looked to for taking additional evidence, and the court has no jurisdiction to admit such evidence in cases where this rule does not apply. Order 41 Rule 27 CPC envisages certain circumstances when additional evidence can be adduced. These are the 1, 2, this we have already seen our Order 27 that we giving. 27B, my lord. B. I'm obliged. My lord, the citations which I have given, my lord, Kindly be reflected, Madam. Mahavir Malata. And second mother is that Ibrahim Mara, two Jatnason. Malat in 2012 Supreme SC, this is Dr. B.S. Chauhan and Deepakar Mishra. Malat, this Union of India versus Ibrahim Uddin. No, but this doctor is Judge Malat. Union of India versus Ibrahim Uddin. And another. Malat in first is starts from paragraph 5, Malat. In case of Mahavir Singh, Malat. Para 5, lots of pictures. Only para 5. Yes. So 25 to 29. But 25 to 29, Malat. But yes, Malat. Each paragraph is given. Entire thing has been explained. Like,
Item number 2.
May I, Your Lordship? Your Lordship, this matter is for quashing of FIR dated 20 January 2026. Your Lordship, I have filed an additional affidavit in which I have annexed a document in which the informant had agreed to withdraw the FIR. And this document was signed in presence of Ayo Doimuk, Ayo Dambuk at Dambuk PS. And it was the same document was submitted. Yes, Your Lordship. Yes, it was signed in the presence of Iodine. Yes, Your Lordship. Your Lordship, it was signed. Yes, Your Lordship. Your Lordship, page number 21, additional affidavit. Your Lordship, it was submitted to IO Dambo. This document was submitted, but the IO Dambo was not present during when this document was signed here. Your Lordship. Your Lordship, I'm sorry. Actually, it was submit. This document was submitted to IO.
Please, Lordship. My lord, this document was submitted before even the agreement was signed before the IO. This document is additional, yes, additional affidavit document. Because this, Lordship, Lordship, pursuant to this, there was an agreement between the parties to withdraw the case also, which is in the main petition. This is just an intimation to the IO that she would like to withdraw the case at the FIR. Yes, yes. No, this was simply submitted to him. Yes, it is clear from the document itself. This document itself. Yes. Yes. This was submitted to the IO. Yes. No, without an application, this was simply submitted. Your Lordship may. No, I'm sure my learned PP will be able to tell if it was submitted.
Lordship, here we have received the case status, Lordship. Here it is, Lordship, it is reflected that the undertaking the withdrawal that they have received, Lordship, that IO received two separate, yes, Lordship, undertaking executed on non-judicial stamp paper by the complainant and the victim before a notary public. In this undertaking, both parties expressed their willingness to withdraw the case.
Yes, Lordship.
Lordship, kidnapping is non-comparable. Lordship.
Kidnapping, Lordship.
Kidnapping.
The complainant has stated that the FIR itself was lodged under misunderstanding. This will be, Lordship, clear from the settlement deed, which is at page 17. The second party lodged the FIR believing her husband was kidnapped, whereas it was a mistake of fact. The first party had never kidnapped the third party.
Lordship, if they have mutually settled, Lordship, before the IO also, Lordship, I have no objection. And 14, Lordship. Non partin.
Non pertinent, Lordship. The petitioner number 3. Yes, petitioner number 1 is complainant. Petitioner number 2 is the yes, 1 is the complainant, 2 is the alleged victim, 3 is the accused person. Dambuk
Rambuk PS cases.
FIR number 2 of 26. This will be in the FIR, Lordship. 2 of 26.
Page 14, Lordship.
Page 14, Lordship, the FIR. Quashing of the FIR, Lordship. Yes. Only the FIR. No, Lordship, it is in a very, Lordship? No, Lordship.
Number 6, Lordship, it is reflected. Lordship.
Yes.
Obliged, Lordship.
Obliged, Lordship.
Item number 3.
Marvelous. My lord, the case before the lordship is of the bail hearing in connection with the operation PS case number 1. My lord, before coming in today, my lord, facts of the case, the CD was called for in the last occasion. So let us confirm first from the PP whether CD is available.
Has been received.
Yes.
Lordship, there is the 11-year-old child as well as the housemaid who was working in the house of the accused. There has been a statement by them that there has been an occasion where they were being tried to be influenced, and their statement to be given to the police was dictated by one of the relative who was also arrested, Your Lordship. Subsequently, the mistress by the accused, Your Lordship. During yes, Your Lordship. Also, two of other sections has been added, Your Lordship, while during the investigation is section 49 and 249B during investigation, Your Lord. It has been added, Your Lordship, two other sections. 49 BNS as well as 249B BNS. Is for harboring of offense, Your Lordship. In regard to this, against two of the other accused person who newly they have been arrested. One is the mistress. Yes, Your Lordship. They have been granted bail by the this is an AB, Your Lordship. Only this prime accused has been absconding, Your Lordship. There was also yes. Only during the yes, absolutely. Yes, there has also been an occasion, Your Lordship, where he has there was a joint account between the accused as well as the victim, Your Lordship. He tried to video and forged the signature of the victim, Your Lordship. That has also been yes, it's still under investigation because those checks, Your Lordship, one of the statement given by one of the person who has been given check, Your Lordship, those are in the process, Your Lordship. As yes, Lordship. Yes, Your Lordship. I'll just
Ma- My lord, the case has been projected that I am not tribal, but the facts I am going to I'm going to demonstrate the court, my lord. That I am that person. I am admitting that I am still absconding because, my lord, I wanted this investigation. My lord, these are the prosecution history, but this prosecution history is, my lord, deviated from the facts. Though this is not the trial court, therefore, my lord, I am not on the merit of the case. Here, my lord, this is in the bail court. I'm praying that I should be granted the anticipatory bail, and why I should be granted, my lord. That on the ground that, my lord, so far, my lord, know the cardinal principles of the criminal law that accused is still innocent, and therefore the bail is the rule and the jail is exception. And my submission in this point would be the present case is not come within the exceptional that I should be sent for jail and the judicial custody is necessary. Why? Because my lord, I am a responsible father of the four children. I am responsible teacher, chairman, my lord. I am the chairman of the, my lord, KGBB, Kasturba Gandhi Balika Vidyalaya, which is, my lord, running at the mowing village, my lord. So I am the chairman of this, chairman of this Kasturba Gandhi Balika Vidyalaya, where in the 87 students are still in the hostel, and I am the responsible person to manage the management of that hostel, my lord. That all the responsible, despite of my responsible in the house, my lord, that I am having the personal responsible for the 87 student, my lord. Now, facts of the case is concerned, my lord. It will be, my lord, important to reflect how and why exactly what is the contention of the bond between me and my wife. Here in this case, the informant is my brother-in-law and the victim is my wife, not other than no other person, my wife. Now, my lord has already seen that there was a Kebang decision between my wife and the other party. That Kebang was held on, my lord, 13 January 2026. This Kebang was only, my lord, for, my lord, having adulteration, having illicit relation with the other person. And that is not other than my wife. My wife was involved in the extramarital affairs with the other person. So, my lord, my submission is that if I am such a person who can commit it up to this allegation, that I know, my lord, when I came to know that my wife is involved in the extramarital affairs, despite of that also, my lord, at every time I am trying to convince my wife not to do this and that all, my lord. Despite my lengra, I mean, my lord, despite my handicap, my lord, I'm trying to, I'm work, uh, I'm work hard for management of school as well as my family. And I am the sole bread earner for the family, my lord. Now come back to the region, my lord. Region of the fighting is, my lord. After the decision, that decision has decided that the person who involved in extramarital affair with the victim, my wife, was imposed 5 lakhs, my lord, as per the customary code, my lord. Thereafter, my lord, I have been treated as my wife that I have already sold to her. And it was since 13 October, since 13 January 2026, I have been treated like that, my lord. Now the incident occurred, my lord, on 23 of January 2023. And, my lord, what is important to, my lord, bring before the knowledge of this honorable court is that the incident was happened in presence of my daughters, my lord, who is 11 years old, my lord. My lord, what incident I admitted that there was a quarrel between us. And in that quarrel also, my lord, in fact, this victim is, my lord, habitually trying to hurt herself in every occasion, so that, my lord, I can be provoked. Therefore, my lord, on that occasion, my lord, despite I am the person who should beat her, but despite she come forward to beat me, and she trying to cut by warning that she trying to cut my hair by her teeth. That is why, my lord, while doing so, my lord, I push her back. And in the meantime, when quarrel started between us, my daughter has, my lord, shouted, and they shouted with crying, and that interrupted my lord, attract the neighbors, and accordingly the neighbors were, my lord, interrupted. And I hope CD will, my lord, fully, CD may reflect that in the CD, the statement of my daughter might be, my lord, recorded. My lord, I know, my lord, the CD has been prepared against me on the ground, and my lord, these many, my lord, many these big people are involved in that. They are trying to put me in the jail, my lord, my lord. But what my lord submission is that so far, my lord, this
No, those checks has been seized, Your Lordship. Yes. Unfortunately, the CD speaks otherwise, Your Lordship. Your Lordship will see the allegation being made through a submission before this court. There is a statement by the mistress of the alleged accused. In fact, he seems to be in an extramarital affair. And on the husband,
my lord,
the
that is the
accused-
counter allegation.
just an allegation.
My lord.
Against the accused person, Your Lordship. The one of the lady who has been arrested and who has been arrested is in terms of section 249, Your Lordship. She has stated that on the earlier occasion when the police had come to her house for searching, he was in fact inside the house, Your Lordship. They have spent the night together, and she is also an employee of the same headmistress of the Kasturba Gandhi, where he is the chairman, Your Lordship. He stayed night with her. Later on the day when the police came in search, she did not produce him, and in fact she lied to the police that there was no one, and she did not even open the door, Your Lordship. Subsequently, on the other occasion when the investigation again approached her, then she revealed the truth. She was arrested subsequently and is on bail, Your Lordship. Your Lordship will see that the child that has been referred to, Your Lordship, there is a maid who is also maid, and as well as a child of the eldest daughter who is 11 years of age, Your Lordship. Their statement also clearly reflects that there was influence being made to change their statement, Your Lordship, and they have been tutored to give their statement by the uncle, Your Lordship. Yes. And also when the matter had come before the trial court, Your Lordship, the only ground on which the trial court not trial court, Your Lordship, before the investigation. When the bail was first filed before the appropriate court, that is the Sessions Court, Your Lordship, on the very ground that he had tried to influence the witnesses because there were only two eyewitnesses. One is the maid, Your Lordship, and the other is the daughter, Your Lordship. There, the IO had produced the CDs reflecting the same, Your Lordship, and therefore he's.
My lord.
Milord,
My lord.
Milord, I am for the victim convenience. Milord, not only that, in addition to the PP, the investigation case diary, They are continuous threatening to the, like, withdraw this FIR complaint. Alleged accuses, and then their family member is threatening to my, through my elder sister, threatening me. And I am like, just recently I discharged from the hospital. Now I am treating a psychiatrist in hospital. So
Yes, my lord. Finally, I have a one line to my lord submission. So for the submission, on behalf of the PP's concern, my lord, this is pertaining to the evidence, and this will be, my lord, look after into the, my lord, in the trial stage. At this stage, my lord, the issue is to whether I should be granted the interim bail or not. So my submission is, my lord, I am the deserved person to be granted anticipatory bail because there is no possibility of the playing and no possibility of, my lord, breach of the any term and condition granted by this honorable court because I am the indigenous of that area, so I have no weight. And my lord, and I am my submission is that let the, my lord, investigation be complete as soon as, yes, my lord, exactly. I am ready to cooperate. Only, my lord, cooperate will be possible the moment if I will be granted the anticipatory bail. Then only right from tonight, my lord, I can appear before the, my lord, investigating officer. My lord, this was rejected by the session judge, the Basar, my lord.
Yes, sir. Yes. Please note on 5/26.
5/2/26.
Oh, yes, WT was filed. Three persons. Yes, sir. 49 is basically allotted abatement allotted 49 and 249 is and 249A. Two 49 is for harboring of offensive. The other person is the housemate. They have tutored you, and therefore 183 of post weaknesses are impossible. Yes, also there is a private receipt service.
for the upper. Through her elder sister to withdraw the FIR. And settle the matter.
My lord, one thing,
Great.
I oblige to the decision of this honorable court, and my lord, some 2-3 lines of my submission be kindly reflected, my lord. In the, my submission has not been reflected, if I am not mistaken. Yes. And I am the responsible. Yes, it is the victim who provoked. It is the victim who provoked, and there is no case. There was responsible father and responsible chairman. A chairman of the KGBB. Yes, school, consisting of the 87 student. And they will sub. Well,
Great room.
all right.
Item number 4 and 5.
Okay, my lordship, it is a civil revision petition by in which the opposite party has to file a counter affidavit. Record has been arrived. Yes.
Item number 4, I am giving to the estimate. And in the, I think like the record has already been made. Probably I'll not file, however, I'm seeking adjournment.
M. Jarang.
In item number 4, only sole respondent. Item number 5, there is yes. In fact, this is a connected matter with item number 5. In item number 5, there is a government and private respondents.
In item number 5, Your Lordship, I am for 1, 2, 3, and 4, Your Lordship. We have already filed, Your Lordship.
He is in item number 5. Lordship. Now we are in item.
Item number 4.
In item number 5, I am petitioner.
And my lordship, in item number 5, I am the respondent number 5 and 6.
Yes, petitioners. Yes. 5 and 6.
1, 2, 3, and 4, Your Lordship.
M. Jarang. 6.
Is entering.
Lordship, in both the case, maybe continue. Much obliged.
Obliged.
8-2, Lordship. Item number 7.
Lordship.
Yes.
Lordship, I'm appearing for the petitioners. Your Lordship, as per the previous order, steps has been taken upon respondent number 2 and the service has been completed. Kindly matter may be fixed for hearing after 2 weeks, Your Lordship.
Respondents are appearing.
Petitioner, I'm appearing for petitioner.
You're for a petitioner.
Yes, Your Lordship.
Whether respondents are appearing. Steps you have taken.
Yes, Your Lordship.
Whether respondents are appearing.
As per the receipt order of the notice, it was received by some other person than the victim. However, it seems that respondent number 2 is being represented by legal aid counsel, Your Lordship.
Respondent number 2.
Respondent number 2.
Okay, you are for respondent number 2.
Yes, my lord, I did not get the copy also till now.
You serve copy?
Yes, Your Lordship. We'll serve it by today.
This is for. Okay. Petition. Miss
K. Yabi.
K.
Yabi.
Nabi, Lani Council for the petitioner. You appeared earlier also for respondent. First time.
Yes.
Okay. Okay. Also had Miss Eugenie for the state respondent, Miss Kiparini. Lani Legal Council would appear on behalf of the respondent number 2, Star. However, she submits that she has not yet been furnished with a copy of the petition. Stop. The Miss Yabi shall furnish a copy of the petition to the Learned Legal Aid Council appearing on behalf of the respondent number 2 within 2 days from today. Start. List this matter next week. Where the record was called for, record is there?
Yes, the record has come.
Okay, then next week, you serve copy first?
Yes,
Okay.
Lordship.
List this matter next week. After a week, huh?
Obliged.
Item number 8. Yes.
May I, Your Lordship?
Hmm.
Lordship, I'm appearing on behalf of the petitioner.
Okay.
Since my senior learned counsel is occupied with some other matter. Your Lordship, the service has been impacted, so I implore the admission to be listed.
Is there any private respondent here? Yes. Whether private respondent, have you taken steps upon the respondent? Okay. Mr.
Sir, Mr. Tiba, sir.
Counsel for the petitioner is present. The service of notice upon the respondent number 2 and 3 is still awaited.
And Your Lordship, I impetrate the interim to be continued.
This is in IA, huh? In view of the above, list is matter after 2 weeks in the main. There is interim in the main.
Yes, Lordship.
What interim? There is no interim, it appears. No interim. When the interim order was passed? Which interim order? No interim. No interim order. The no interim order will continue.
Oh, sorry, Lordship.
Okay. After 2 weeks.
Much obliged.
Lordship, TCR may be called for, Your Lordship.
Not called for.
It was called for, but then it seems the registry has not yet received the TCR. It's not reflected in that cause list.
Yes. File for resource, as called for. In the main, huh? In the main, percent, so. That's good. Okay. In the interim, there is a, no, in the IA, there is the interim.
Yes, yes, Your Lordship.
In the IA, the interim order pass as the continues in the next resolution. In the main, presence record, presence of the counsel for the petitioner and Mr. for the state. Mm. See, the record reveals that the addressee could not be found in the given address. You find, probably you may have to find out the proper address of the respondent. He could not be found. Then in the main, huh? View of the office note dated 4/2/2026. Mr.
Tiba, sir.
Sir, Nana counsel for the petition said that. You take fresh steps.
Sir?
Okay.
Oh.
Then some steps you may be allowed to ascertain the current address of the respondent and take necessary steps and take fresh steps thereafter. They are allowed. Press steps after ascertaining the proper and current address of the respondent within a week from today. The file to record is called has also not yet been received. Start the registry service to remind that for trying to record. So list this matter after 3 weeks. Okay, both, huh? 3 weeks. Make it 3 weeks. Okay.
Much obliged.
Item number 9.
Nay, Your Lordship.
Yes.
Lordship, I beg to mention item number 7 again. Your Lordship, I forgot to mention yours interim.
There is interim.
Yes, Your
Okay,
Lordship.
item number 7.
Yes,
The interim order past address shall continue till the next date of listing. Okay.
deeply obliged.
My lord, item 9, press step was already taken through the speed post. And the report is awaited, respondent number 3 to 6 awaited, and respondent number 7 that returned. So we may allow to take press steps. Respondent number 7 more particularly.
This is unserved notice, yes. Upon respondent number 3 to 6.
3 to 6.
What is written there? Not. Readable. What address is this? So this so and so. No, this is not the proper address. It appears.
So I mean,
Gumto is a
Gumto, not Gumto. This actually that's office that all Arunachal Pradesh Gangbra Welfare Association president. That's
you should mention that.
and that is there at
No, it is not there.
Banardeva.
Hmm.
So I may allow to take praise.
Okay. Mr. Ragamlani, Council for the Petitioner is present. The unserved notice upon the respondent number 3 to 6 return with the postal note that the address not proper. Huh? In view of the above, Mr. Ragamlani, Council for the Petitioner, prays for allowing him to take fresh steps upon the said respondent. Prayer allowed. Steps upon the respondent number 3 to 6. What about 7 and 7?
7 is that president all Arunachal Pradesh Gangbra.
Okay. 3 to 6 and 7. Huh?
7, yes.
7 also. Within a week from today after. In the proper and correct address of the respondent. Huh? Okay. By a speed post as well as by usual process. Okay. This is matter after 3 weeks.
3 weeks.
Okay.
I will like that.
Item number 10.
My lord, I need some time to take justice service upon the respondent number 1 and 2, ma'am.
Justice service not yet taken.
Yes, ma'am.
Taken.
No, ma'am, not that.
Okay. Mr.
The other man.
The other land council for the petitioner prays for father. You are for
Respondent, Sita.
respondent number
3, my lord.
3.
Yes.
Okay. Land council for the petitioner prays for father 1 week time. 1 week.
2 weeks, ma'am.
Father 2 weeks time to take steps upon service or notice upon the respondent number 1 and 2 by a justice service. Staff, prayer allowed. Notice. The service notice upon the respondent number 2 be taken by a Dusty by way of Dusty service within 2 weeks from today and file affidavit, compliance affidavit thereafter. Staff, Mr. Tadab, Kajit, Lani Council for the respondent number 3 is present. So this is okay. Appear on behalf of respondent number 3. Okay. List is matter after 3 weeks,
Madam.
4 weeks.
2 weeks.
You are taking Dusty. Is Dusty how long it will take? Dusty within 2 weeks. Then Dusty within after 2 weeks. Okay. Okay.
Madam, there is an incumbent.
The interim order pass earlier shall continue till the next day of listing. Okay.
All right. Item number 11.
Yes.
Lordship, the service upon respondent number 2 is completed. The matter may be fixed for hearing.
Awaited. It's awaited. No. Just a minute. Serve understood is. Okay. You have taken a step by way of someone respondent number 2. Okay. How many respondents are there?
One. State,
Hmm?
the state and the private respondent.
Okay. The office note dated 8/10/2025 reflect that service of notice upon the respondent number 2 was a return of the return after served with
13.
staff. However, no one appears on behalf of the respondent number 2. Respondent number 2 is informant.
Yes, Your Honor.
Whether record was called for.
Yes, Your Lordship, the report has come yet.
Just there.
No,
And
I deeply apologize, Your Lordship. Seems the record has also not come.
no. Okay. However, the trial court record. It was called for, otherwise, however, the code,
Your Lordship, it
Can-
seems the
however,
investigation
the-
has not been complete.
however, the record as called for has not yet been received. Staff, in view of the above, the registry cell is to remand for
Your Lordship,
trial court record.
I've just
Can
been
copy of
informed
the trial
that
court
the
record.
matter has not been charged sheeted yet.
Not yet.
In that case, CD may be called for, Your Lordship, if that is the scenario.
Okay, then, okay. Then in view of the above, list this matter when
On 13th of March,
13th of March. On which date? The trial court, the case study, the updated case study would be produced. Okay, by the Lana Edison PP. Okay.
Item number 12.
Lordship's service completed in respondent number 2. Matter may be fixed for admission.
The office now dated 9/2/2026 reflect that the service of notice upon the respondent number 2 was received. This is what passing petition.
Yes.
No one appears on behalf of the respondent number 2.
Lordship, on this occasion, Lordship, we have to, Lordship, furnish case study, Lordship.
So, case diary or case record?
Case study, Lordship.
Case diary was called for.
Yes, Lordship. And yes, call for, but we have not received till that. On
Okay.
the, yes, Lordship.
In view of the above, this matter. When?
13th of March.
13?
Yes.
13 March. Why 4/13?
Lordship, my senior is from Guwahati.
13 is Friday. Why Friday? You've chosen Friday. At least 12.
Okay.
On which date the line addition PP shall produce the updated case diary. Okay.
Second copy of the case.
Scan copy of the updated case
Right,
diary.
then, Lordship.
Develop.
Item number 13.
I'm referring for the petitioners. Last occasion, the trial court report was called for.
Yes.
Yes.
Then what happened? Not yet.
We have, the registry has received it, Your Lordship. The trial has not proceeded, Your Lordship. It was on, the only steps taken was for committing the matter, Your Lordship.
Received.
Yes.
Okay. So who else is the respondent?
It's a joint petition, Your Lordship.
Joint petition.
On the mutual settlement.
Mutual settlement.
Yes, this matter may be taken up for disposal.
So, what is the offense?
Offense is
So
279, that is negligent driving. 338, causing grievous hurt by act endangering life and personal safety.
You have any problem?
no, Your Lordship.
No problem.
Yeah,
It's accident case.
It's an
Yes.
accident case and they have been compensated in terms of, money.
Adequately compensated.
Yes,
He has received.
yes. It's a,
Okay,
there's a
thereafter-
payment of 1,50,000. which
Okay,
is-
where is the settlement? Let us see just once.
Settlement is page, annexure 4, page
54.
54. Yes.
Okay. Okay, so hard Mr.
B. Padu.
B.
Padu.
Pardon, Learned Counsel for the petitioner. Also had Ms. Chini. Learned additional PP for the state. Staff, huh? This petition under section 528 BNSS 2023 has been filed jointly by the who is the informant?
Informant is petitioner number 1.
One is informant.
Yes. 2 and 3 victims and 4 is the accused.
Two is
2 and 3 victim.
victim,
Yes, and 4 is the accused person.
accused. Okay, the informant, the victim, and the accused. Praying for quashing of accused in Papu Hill PS case number 01/2022 and 2022 under section 279 338 IPC. Praying for quashing and setting aside of the GR case number 01/2022 arising out of the FIR number same against the petitioner number 3. Start.
Petitioner number 4.
But we have written 3.
4.
4.
Where?
It title, course title, it is for Nima
Course
Pasang.
title?
Nima Pasang.
See page 1. Which has been registered under section against the petition number 3.
So it's wrongly written. Because it is page number 3, 4. Page number 3. That is serial number 4 is the accused person.
Coming to accused. Here also you have not written accused. But then in the petition it's 3. Will We'll quash in respect of petition number 3 only. Unless you correct it. Okay, correct it, huh? We'll pass over. Okay. No problem, otherwise this.
No, I don't have any issues.
3 is marriage, corrected as a 4. Okay.
No, Your Lordship.
Okay, we'll dispose of.
Deep.
Otherwise, case charge sheeted is pending before which court?
JMFC, UPI.
Okay, case pending for JMFC UPI, huh? At what stage? Charge frame? No.
No, only committed.
Yes.
Committed, okay,
JMFC.
Yes.
okay.
Deep.
Item number 15. Should take this one also. This is, give it in the, dispose, huh?
Map, please.
Yes,
Yes, yes.
this is 15. Okay.
And in this criminal relief petition, IA is for suspension of conviction and release on bail mallet. IA mallet will just take to the judgment and order was passed on. Judgment was passed on 22/10/2025, and order was passed on
No, just a minute. There's a respondent also.
yes, complainant is there.
Okay, notice served.
Notice
Okay, what happened? Service for, who has respondent number 2 retired from service
okay.
and is not available at drawing. You have to ascertain the present address. Take steps. There were no steps. In the IA, huh? The office note dated 4/2/2026 reflect that the service of notice upon the respondent number 2 return to the postal comment that the said respondent number 2 has retired from his service and is not available at drawing staff. In view of the above, the applicant petition scope applicant shall ascertain the correct, the present and the correct address of the respondent number 2, and thereafter take steps for service of notice upon the said respondent number 2. Steps within 3 days.
3 days.
Steps be taken within 3 days by speed post as well as by usual process. Okay, step be taken by speed post as well as by usual process within 3 days from today. Huh? Stop. List is matter after.
Can it be the IA can be heard before notice is
No, it cannot be. Because it's conviction only.
Yes, conviction.
Okay.
Yes.
Okay. After?
Or then we may also allowed to serve the state if possible can be done.
Who is this? Respondent number 2 is.
And the notice has to be served through PP. I think it has to be served through PP.
Okay.
You serve copy to the PP.
Okay, then the notice be taken to be routed through
the office of PP laws.
office of the PP. Okay.
And let date may be given so
When?
that.
Then first of all, you have to take steps.
Yes. Within that we can do the.
Now you see, it appears that you have to first ascertain the proper address where he is, because he is retired and no longer staying in the said address at drawing. You have to ascertain the proper address. I think 3 days also will not be sufficient, because you have to ascertain the correct address, present address of the informant.
Right.
Then I think say around 10 days. Okay, make it 10 days to ascertain and to take steps. Okay, thereafter take steps.
First, I have to ascertain, and then we can take steps to the.
Then ascertain the present and current address of the respondent number 2 within a week, and thereafter take steps upon the said respondent
through
the
Routed to
office
the
of the,
office of the
to
PP.
the office of the EP.
of collection.
Okay. Within another 1 week. Okay, list this matter after 3 weeks.
3 weeks.
Okay.
Obliged.
Okay.
Item number 16.
None appears on behalf of the parties. List this matter next week.
Item number 17.
Lordship, your conviction period is over, Lordship. This, the date,
Is
yes, Lordship. The judgment, Lordship.
No, that is there, but then have you confirmed that he has,
Lordship, as per the Lordship, the date of, day of judgment, Lordship, is, 3
that
years
is there, but
punishment,
then how
Lordship.
long he was? Judgment immediately arrested. Was he taken under custody immediately on the delivery of judgment? You have to ascertain, it appears, whether he is still there or already released.
Yes, Lordship, date will, I'll take the
Yes,
instruction, Lordship.
Laji is for
I'm for the appellant.
appellant.
Yes.
Private,
No, my lord.
Amicus,
Amicus.
Lordship.
Amicus. You also have no idea.
I have no idea, ma'am.
Okay. Miss Lakshmi Lana additional PP submits that the judgment, when, where is the,
Judgment at page
Page
26.
26, Lordship.
it was on 69,
Yes, Lordship.
69, 20.
judgment.
Sentence was 3 years.
Okay, was, judgment was delivered on 16/9/2021. And sentence was awarded on the same sentence was awarded to the convict on the same day. No, he was convicted on the same day, sentencing him to undergo in rigorous imprisonment for how many days? 3 years.
3 years, Lordship.
3 years. Fine is also there.
Yes, Lordship, 1,000.
With fine,
My lord, I think he was taken on custody on the same day.
on the same day.
Yes, madam. Page 45 is the last paragraph of the judgment.
The last paragraph.
Para 38. Convicted under the child section of the Act and taken him into custody to serve a sentence. Page 45.
45. Where do I find?
Judgment.
Paper book, Lordship. page
Paper book, page 45 is page 20 of the judgment.
Page 45.
Yes.
Where is the sentence or sentence is next page?
There are 38.
47,
Lordship.
48.
Yes. 46 onwards is the order.
No, conviction on convicted on the same day and taken him into custody, huh? For sending him to jail in execution of the conviction. Okay.
Although, my lord, he has completed the sentence, jail sentence,
Hmm.
but since there is a civil
He-
consequence out of this conviction.
Yes, it appears. We do not know whether he has already been released or not.
Yes.
However, okay.
It's
From the record, it appears that the convict has already completed his sentence of 3 years. However, Mr. Laji, Planet Legal Aid Council and additional PP has no idea as to whether the convict is still inside the jail hazard, or he has been released on bail. So in view of the above, the jail authority, which jail?
Bomdila,
Bomdila, then it would be
probably, my lord, shifted to Julang, because the observation is there. Jail Superintendent Bomdila will make effort to shift the convict UTP at Julang after proper.
Julang.
consultation with jail
Then
superintendent.
it must be Julang only.
Yes.
The concerned jail authority. The jail authority of district jail, Julang, stroke, concerned jail authority, maybe sent somewhere. We'll say Julang only.
Yes, Lordship, right
Is
now we have
directed.
to, yes.
Okay, directed to inform regarding the status of the convict within a week from today. Okay? List this matter next week, list this matter again on. We'll fix it. Today is 11, then we'll fix it on
Yes, 12.
12, then we'll fix it on 19. Okay?
19, my lord, I have personal difficulty, my lord.
Oh, when do you want?
17 or 18?
Telephonically also you can confirm.
Yes, Lordship.
Okay, if it is possible, then we'll fix it on 17. Okay?
Yes, Lordship.
Mm.
Obliged.
List it on again on 17.
Most obliged.
Item number 6.
Yes. This is for further cross examination. Okay. Please continue with. By the way, Mr. Deori,
Lordship.
this earlier one order wherein mistakenly this the evidence was typed, serial number 15, 16, 17, 18. Not required. Yes, yes, only recording.
Yes,
So whether this or the certified copy of this order was obtained,
No, my lord. We have not.
anyone obtained? Okay, not obtained,
Last occasion.
because this will disturb otherwise. If not obtained, it is not signed also.
It's not signed. Last occasion